We've passed out some evaluation sheets to you that I would ask that you complete before Mr. Higgins gets in. Hopefully, maybe you've already done it already. And before Mr. Higgins gets up to the podium, I'm going to tell you the format we have here. Mr. Higgins is going to make a presentation, and then following that, we will show a brief presentation about arbitrations in general. And hopefully you will enjoy it. The topic is arbitration review at PERB. I'd like to introduce today, we have a few of I think all of our staff is here. And let me just introduce to you the staff members that we have here. Erica Bolcom is over in the corner. Ben Kraft, just raise your hand. Kobe Harmon there. And is there anybody else here? Oh, David. David is here. And David McFadden. And then we have Lindsay Maxwell, our supervising attorney, that's in the back. Oh, also, I never get to acknowledge them, and I'm going to do that today. And that's Felice Robinson in the back, who's our paralegal. And then we have Cheryl Harrington, that's over there, who's the person who receives all of your acknowledgments and sends out confirmations to you. Really very, very hard worker for us. And then also Joyce. Joyce, raise your hand. Joyce? Right. She's one of our part-time contract employees. So, for the people who just came in, we'd like you to fill out, sir, a survey for us. And so, did this gentleman here get? Felice, did this gentleman here get? Are you going to give him a survey? Okay. Thank you for bearing with us in regards to setting up today. What we're going to do, someone may still need to come in and fiddle around with our projection, but what we're going to do is get started so that we don't delay your leaving today. All right, Mr. Higgins.
Good morning, everybody.
Morning.
This is going to turn out to be a very timely discussion today. But I'm going to ask you the question: what has Tom Brady got to do with what I'm going to be talking about today?
That's where his case is going to end up.
Did everybody hear what this man said? Huh? No. He said that's where his case is going to end up. And it may very well be. That's the whole point. I think what he and I think the NFL Players Association is doing right now is trying to decide whether they're going to take this case, take the penalty for Brady to arbitration.
What's the penalty?
Well, the penalty is for suspension of 4 games, and now I'm not sure whether the team can file a grievance for the penalty against it. There's a what is it? Loss of first and fourth round draft choice and $1 million fine. So ouch is right. Yeah. But anyway, that's what we're going to talk about today. We're going to be talking about a little bit about grievance arbitration. We're also going to be talking about interest arbitration. But first, let's talk a little bit about what is arbitration. It is not court. It is not court. If you look at the notes that I prepared in advance, you'll see a rather long definition of arbitration coming from El Khoury and El Khoury. El Khoury and El Khoury, by the way, is a big, thick book put out about, it's the Bible of arbitration. Everything anybody wants to know about arbitration is in El Khoury and El Khoury. That's the book. And this definition I took out of El Khoury and El Khoury. Without getting into all the details of it, there are very important elements to arbitration. First, it is a private adjudication system. It is not court. It is not like going to D.C. Superior Court. It is not like going to the Supreme Court. It is a private system that the parties themselves have agreed upon. It is informal. It doesn't have all of the bells and whistles that go along with formal litigation in court. It is not created by Congress. It is not created by the DC City Council. It's not created by the state of Maryland. It's created by the parties. The parties themselves have sat down and agreed upon a mechanism for resolving disputes that they can't resolve themselves. They try to work out in collective bargaining, and they can't resolve them. So they go to a neutral. And what you're going to see, this film today, is a film called The Art and Science of Arbitration. It's a film made by the College of Labor and Employment Lawyers, and it is composed of excerpts from interviews of a lot of arbitrators all around the country, very prominent arbitrators, people who are very well known in the field. One of them is a DC resident, a guy by the name of James Harkless, and you'll see him on the screen. I don't know whether he's had any PERB arbitration cases or not, but I know he lives here in the District of Columbia. And lastly, what arbitration does, it's a quick resolution. Okay? It's not an interminable court proceeding in which you hear that there's somebody sued somebody and you don't find out about the decision for 10 months, 12 months, 15 months later. An arbitrator's decision is usually quite quick. And in fact, most agreements for arbitration provide that the arbitrator will get his or her decision out in 30 days. And they don't go to jail if they don't do it, but they're encouraged very strongly to get their decisions out in 30 days. So it's a quick resolution of a labor dispute. Okay. What I want to point out, though, is arbitration. Whether you realize it or not, arbitration is an enormously fast-growing method of resolving disputes, not just in labor cases. Okay? Arbitration is used a great deal in resolving commercial disputes. If I were building a building over here, and I was going to do a lot of financing with the bank and buying a lot of things from suppliers and so forth, the chances are great, okay, that at some point we would say, look, let's have a means of resolving disputes between us. I'm not talking about disputes between the people who are building the building. That's labor arbitration. I'm talking about the people who are doing the business people. They will have an agreement between themselves to resolve disputes using arbitration. Why? Because they don't want to go to court. It's too expensive, it takes too much time, it can be done much more quickly. So commercial arbitration is very big. Product warranty arbitration is very big. And everybody in this room, I suspect, is a party to an arbitration procedure and that bound you to it. Anybody know what I'm talking about?
Interest arbitration.
Not interest arbitration. Well, get into a fight with Visa and you're going to find out. Or get into a fight with American Express and you're going to find out. Because when you joined, signed up for those cards, one of those little fine print underneath there says, if there's any disputes between you and Visa, it will be resolved by an arbitrator. You will not be able to sue Visa. Okay? I think that's probably right. Just you could double check it. And every time you get a warranty with sign a warrant when you buy your car, I'll bet you signed a warranty, an agreement that said if you have a fight with General Motors or Ford, you'll take it to arbitration. They even go to the point of saying, and it will be arbitrated under the rules, the arbitration rules of the state of Maryland or the state of Washington or the state of whatever. It's all set up there, and you are all parties to it, whether you know it or not. Now, what's the advantage there? Well, the advantage there is more for the company than it is for you. And the reason it's there is probably can't get punitive damages. You can't get punitive damages from that. You can, the only thing you get is what your actual losses are. So, anyway, there's arbitration in domestic relations. Domestic relations disputes can sometimes end up in arbitration. In the private sector, labor arbitration is a substitute for the strike. Okay? That's where it comes from. It was a means by which management said to the union, look, we don't want you to strike every time you've got a dispute that you're not happy with its resolution. Every time we fire somebody and you can't get them a job back, we don't want you striking. So we'll agree to a provision in our contract that says you won't strike, you'll take the case to grievance arbitration. You'll take the case to grievance arbitration. Management, and the union's advantage of that, of course, is it simply doesn't have to call people out every single time it's got a dispute, or every time it's got a beef that it can't resolve with management. So it's really, it's truly a substitute for the strike. In the public sector, DC government, okay, it is a substitute for the strike, but it's a substitute for the strike that the power of which you don't have. Striking is prohibited under DC government, under the CMPA, just as it's prohibited under the Federal Labor Relations Act, just as it's prohibited under most state labor relations agencies. So why do they have it there? Oh, because it is a means of saying to giving employees a place they can resolve their disputes. They can't strike, so they need to have a place to resolve their disputes, and that place is arbitration. Now, this gentleman here just a minute ago said interest arbitration. There are two kinds of arbitration. The one we always hear about is grievance arbitration. That's where there's a dispute at the work site, and there's a question as to what does the contract, how does the contract apply to what management just did? Did management have a right to fire that guy? Did Roger, or whatever his name is, Goodell, have a right to suspend Tom Brady? And if he did, was 4 games too much? Those are grievance arbitrations. Those are beefs that the employees have with the boss, and they usually they take it to arbitration, and the arbitrator has to decide whether there's good cause for what the employer did. That's usually what the arbitrator decides. Is there good cause for what the employer did? Is there a basis for what he did? The second type of arbitration is interest arbitration. Okay? Interest arbitration is a wholly different thing. Interest arbitration is a method of arbitration that you really don't find very much in the private sector, but it's a lot in the public sector. And it's very much alive and well in DC government, very much alive and well. That's a mechanism when the parties are in negotiations for a new contract, they can't reach agreement. So instead of striking, which they can't, or locking them out, which they can't, which the management can't do, okay? CMPA, the city council, has set up a mechanism called interest arbitration. That is, you go to an arbitrator, a neutral, a private citizen, okay, this is what he or she does for a living, and you make your cases for what the collective bargaining agreement should be. And the arbitrator decides what the contract's going to be. and his or her decision is final and binding. Okay? And both of those are elements of PERB, and PERB has an involvement in both, and we'll talk a little bit about those in just a minute. In the film you're going to see today is almost entirely dealing with private sector arbitration. And it's almost entirely dealing with grievance arbitration. But the fact that it's all private doesn't make it any less relevant to you in understanding what the process is. This is not a training film, by the way. You're not going to see a training film on how to arbitrate a case. You're going to see a film about what is arbitration and how arbitrators think, what they're looking for, what kind of people they are. You're going to come away from this thing, I think, with a good understanding of what an arbitrator does and what you can expect when you have a case that goes before an arbitrator. There are three cases the Supreme Court decided in 1961. It's called the Steelworkers Trilogy. They're all cases that arise out of collective bargaining agreements between the steelworkers and various companies. Cases all went to the Supreme Court. They were all decided right around the same time, and they all are extraordinarily strong endorsements of grievance arbitration, and great limitations on the courts as to what they can do with a case coming before them where a party is challenging an arbitrator's decision. You can take a case, you can appeal an arbitrator's decision, but when you appeal an arbitrator's decision, the likelihood that you're going to get that arbitrator reversed is pretty small. Those standards, what the Supreme Court said in the trilogy, kind of got repeated in CMPA, in the statute that governs you. And by the way, they also got repeated in a thing called the Federal Arbitration Act. And what that says is you can only appeal an arbitrator's decision if you can establish that the arbitrator exceeded or was without authority for what he or she did. That's one thing you can do. You can appeal if the award is on its face, emphasize the word on its face, contrary to law and public policy. Or third, if the award was procured by fraud or collusion or other illegal means. The long and the short of that is, when you appeal, if you have an arbitrator's decision in a case involving, I see somebody from the police department back there, a case involving MPD or people involving Department of General Services and so forth. If you want, you can appeal. If you get an arbitrator's decision that you don't like, you can appeal it to PERB. You can say, hey, this guy, we hired this guy, and he did a lousy job. We're not happy at all with what he did. He rewrote our contract. This isn't what we agreed on. You can appeal it to PERB. Very, very, very limited scope of review. Okay? And it's those three things, those three elements. By the way, they're set forth in the notes that I gave you. Those are the three standards. And when you go and look at the cases PERB's decided involving those things, you'll see that PERB follows that rather rigidly, very careful. So the point being here is that under CMPA, the arbitrator really has an enormous amount of power and authority. Unless he or she really, really stubs his toe, chances are whatever that arbitrator decides is going to be the result. That's going to be the end of your case. Okay. PERB, there's a wonderful quote from PERB as to what it sees the arbitrator as being. And PERB said, in a case, by the way, a case involving the Metropolitan Police Department and the Fraternal Order of Police, PERB said, quote, the arbitrator is the contract reader, and his interpretation of the law becomes part of the contract. and is thereby part of the private law governing the parties' relationship. So, it gives you a sense that PERB has, like I say, has a great deal of respect and is very strictly construes arbitrators' decisions and the limitations that CMPA has put upon it. All right, we're going to see this movie. I guess that shows my age, isn't it? I guess we call them videos. Is that what they call them now? Videos. We're going to see this video. And I've got to tell you something. It's just, if you don't know. My father, God have mercy on him, was a labor arbitrator up in Massachusetts, and very successful, as a matter of fact. And at the very tail end of this video, there's a picture of my father in there and a comment about him. So watch for it. I'm rather proud of it, and I'd like to just note it, okay? All right, can you turn it on, please, ma'am? And then we'll take about 10 or 15 minutes at the end. This is, by the way, it's about a 15-minute video. And at the end, I'll open up for questions about PERB and what you can do in terms of PERB, and any questions you have. Yes, ma'am. Oh, it's warming up. Well, while it's warming up, any questions about what I just said? No? How many people in the room have actually been involved in an arbitration case? Oh, so you're all old pros at this, okay. All right. Well, I hope I think you'll enjoy this film. And as I say, watch for Jim Harkless. He's a DC resident. The rest of the arbitrators are from all over the country.
It's a movie.
No, these are just old films.
No,
To get you all excited about it.
You didn't get it.
The power, but the rise of labor unions in the early 20th century began to change that imbalance. Angry employers where there are workers and employers, there are disputes. Traditionally, employers had all the power, but the rise of labor unions in the early 20th century began to change that imbalance. Angry employers could still punish, but workers had leverage. They could stop work and they could strike. Chicago, 1937. Strikers and protesters trying to unionize the Republic Steel plant clash with police in what's called the Little Steel Strike. Big Steel, that is U.S. Steel, had already signed the union contract. As the unarmed crowd marched across the prairie, police opened fire. Arvid Anderson was there and deeply affected by what happened.
I was a 15-year-old living in Hammond, Indiana, and I took a streetcar ride from Hammond to South Chicago to the Republic South Works, where a strike was engaged. I was there the day before and the day after. 10 strikers were killed, 7 were shot in the back.
The strike became known as the Memorial Day Massacre, one of the bloodiest in American labor history.
And that made an indelible impression on me that labor relations needed peacemakers.
Labor relations needed peacemakers. At the time, that almost visceral need sparked the growth of a kind of voluntary alternative dispute resolution called labor arbitration. And its big push came during World War II.
Particularly with the impetus in the war, both parties decided that rather than striking or locking out people or engaging in other kinds of economic warfare, we will find someone who will decide issues for us that we can't resolve. I mean, that's a heavy responsibility, but you're built into that system as the last decider.
I'm one of those last deciders, have been for 25 years. My name is Alan Simonet. In the 1940s, the War Labor Board's Tribunal of Arbitrators was the impetus for making arbitration part of accepted labor practice. But not until 1960, in the Steelworkers Trilogy cases, did arbitration win full legal standing, with its decisions final and binding. We'll get to that later. The War Labor Board served as the neutral third party in disputes between unions and employers. It practiced both interest arbitration, settling disputes over terms to be included in new collective bargaining agreements, and it practiced grievance arbitration, using its own and outside arbitrators to settle disputes over the interpretation and application of existing agreements. The board's arbitration authority went a long way to preventing strikes that could have hurt the war effort. Our focus in this program is grievance arbitration. And a question I'm always asked is, how does that differ from another form of dispute resolution, mediation? In a word, power. The arbitrator has the power to resolve a dispute by issuing an award. The mediator doesn't.
The mediator works with suggesting areas of compromise, trying out ideas, eliciting from the parties where their priorities are, and working towards a solution that both sides can live with. So the key word in mediation is compromise.
An arbitrator is akin to a judge. The parties have come to him and said, we can't resolve this dispute, whatever it is, just cause of discharge, contract interpretation, whatever. You decide it. And so they hold a hearing, you hear witnesses, they often write briefs.
Just like a trial.
Just like a trial, and you decide it.
Arbitration and mediation actually require quite different abilities.
You could be a very good arbitrator and not be a very good mediator. A mediator has to be more personable. Because the arbitrator decides, the parties don't necessarily have to like you very much. They just want your decision. And they're glad if their decision is in their favor. Whereas in order to get people to agree, more likely than not, you've got to really get them to like you, to trust you, to confide in you.
After the war, many of the War Labor Board's alumni continued their arbitration careers, and in 1947 founded their own organization, the National Academy of Arbitrators. Yet even then, arbitrators practiced in an unsettled climate because the scope and procedures of arbitration were still developing. Ted Keel was right in the middle of it. For 40 years, Theodore Keel was actively involved as an arbitrator and mediator in nearly every major labor dispute in New York City. In 1949, wildcat strikes plagued the city's transit system. So Mayor William O'Dwyer and Mike Quill, the founder of the Transport Workers Union of America, chose Ted Keel to be their impartial arbitrator. Newspapers dubbed him the Transit Czar.
In the middle of the night, a wildcat strike developed at the 54th Street garage led by some dissidents who were not part of Quill's team. Quill didn't know about it until he was called by the press. And then he did something that was very strategically wise. He didn't control the 54th Street garage, but he controlled the other garages in Manhattan. So he immediately, even though he was violently opposed to this wildcat and had agreed to have me as the arbitrator to avoid them, he enlarged the strike to include all of the city. And he thereupon had control of the strike, which he wouldn't have controlled if it was just the 54th Street garage. So now he was the violating the agreement that led to my appointment. And the Herald Tribune had a big editorial. Mr. Keel should resign, because I'd been repudiated. Though I didn't know what to do about it. There was logic in their position. So I announced that I intended to resign, but would not resign until this matter was resolved.
They resolved the dispute, agreed on procedures. Mr. Keel didn't resign, and labor relations strengthened in the city. On the Chicago War Labor Board, Frances Bairstow was a pioneer. She went on to have a long and storied career as one of the few early female arbitrators, one of the few female academics in the field, and a longtime professor at McGill University in Montreal. Early on, she felt she needed a certain kind of preparation.
It always bothered me that I never actually worked in a factory. And I thought to be really good in labor relations, one should get industrial experience.
So before her 1954 Fulbright at Oxford in industrial relations, she decided to get that experience at aircraft manufacturer Lockheed.
When I got to Lockheed, they wanted to give me a job in the labor relations office. I said, no way. I want a real line job. And so the guys sat there like this, well, we give her, she's just crazy and so she'll last a week. Anyway, they gave me a very dirty job in the plastics department. I don't know if you know what it's like making plastic parts, but they use this fiberglass and arborite, and it gets in your skin and it's itchy. But I learned more in that period, 10 months at Lockheed, than I ever learned in 4 years of education about labor relations. I had never punched a time clock. I never found out what time study was about. I learned all those things, but most important, a lesson that's lasted me all my life was the intelligence and ability and common sense of so many people who are stuck in routine jobs. I savored this experience because I thought someday somebody's going to turn to me and say, what do you know about it? Did you ever work in a factory? Well, my time came when I was in England, because I taught a labor course for the Transport and General Workers Union in the south of England. And these were truck drivers and merchandise workers. And there was one very hostile, antagonistic guy who you could tell he wasn't going to take anything from a woman, talking about labor relations. So he got up and yelled one day and he said, what the hell do you know about it? Did you ever work in a factory? Oh, my moment has come. And I said, yes, I did. What kind? And I said, aircraft factory. And he said, I thought so. You never worked in a steel wire rolling mill.
Arbitrator James Harkless had worked in a factory as a young man, spending summers in the foundry at Ford Motor Company's Rouge plant. He put sand cores into ovens that topped 1,700 degrees to harden them as molds for steel car engines. That work and his early experience representing unions was foundational.
I actually was in the bargaining in Springfield, Massachusetts, an IUE local, where it became so emotional and the stakes were so high between the parties that one of the representatives on the union side had a breakdown and so swallowed his tongue. It was a very startling kind of thing to happen, but it shows how intense these matters can be. So that meeting with union people, planning arbitration cases gave me a lot of insight as to how workers think.
In the 1950s, after graduating from Harvard, Mr. Harkless joined Grant and Angoff, the largest New England firm representing unions. Industry still didn't like arbitration much.
The law was very uncertain, so the General Electric, where we represented the union, we always had to go to court to force them to arbitrate. No grievance was arbitrable as far as GE was concerned, so we had to go through the process of forcing them to arbitrate.
But if the company wouldn't agree to arbitration, workers themselves had to take their grievances to court. And usually they lost. George Cohen had just started work with the National Labor Relations Board.
Working men and women had a much less likely success rate before federal district courts than they were having before impartial, neutral labor arbitrators.
It was an untenable situation for workers until 3 Supreme Court cases in 1960 called the Steelworkers Trilogy. Bredhoff and Gottesman, the firm Mr. Cohen later joined, handled all 3 cases. The Supreme Court's ruling was landmark legislation. It made grievance arbitration a preferred dispute resolution technique superior to external litigation in court and forever changed labor management relations.
So let's take it from the standpoint of working men and women and their union. Virtually all collective bargaining agreements had hundreds, if not thousands, of terms and conditions that were part of that agreement. And now, anytime an individual employee complained that the employer had breached the agreement or violated it in any way, that person had a right, through his or her union, to file a grievance and process it to arbitration for a final decision.
Well, good morning, everyone.
The trilogy went on to say to those working men and women that if the arbitrator issues his or her ruling, that ruling will be subject to a very narrow court review, and except in extraordinary circumstances, all the parties, the employer, the union, and the working men and women, will be governed by that award that the arbitrator issues. And these were neutral people, the arbitrators.
The union has the right to grieve and arbitrate this employee's dismissal, and that's what it's doing.
So the arbitrator's decisions were final and binding, and courts could only overturn them in rare instances, such as arbitrators' misconduct or exceeding their authority under the provisions of the collective bargaining agreement.
Mr. Lovell simply does not meet the definition of temporary employees.
The combination of those two aspects of the decision, in essence, elevated the whole world of grievance arbitration beyond anything that had been before it And here we sit here today, Trilogy is still alive and well, and those basic principles have governed the way in which companies, unions, and employees have conducted themselves for lo these many years. So it was almost impossible to describe the significance it had.
So what happens in arbitration? What's the process? As we said, it's very much like a trial, minus the courtroom and judicial roles. Often, the arbitrator gets a sense of the resolution right from the start.
That feeling of knowing where the right answer is can happen as early as opening statements. Parties might not want to hear that, but it's true that we begin formulating our thoughts and seeing where pieces fit from the very beginning of opening statements.
Would you raise your right hand to be sworn? Do you swear to tell the truth, the whole truth, and nothing but the truth in the testimony you're about to give?
Advocates present evidence. Witnesses testify, and credibility may be key. But can arbitrators tell if a witness is lying? It's not easy.
Sometimes the nervous, shifty-eyed, fidgety person is telling the truth. And the straight in the eye guy is not, you know. You just have to sift through it and try to determine what is the reasonable possibility here.
Were you suggesting that he worked for another company and Fairpoint hired him away?
In the hearing, arbitrators often ask for clarification.
When there's something you don't understand, it's not shameful to say, excuse me, I didn't understand what you said, or I couldn't follow that.
But what if crucial information doesn't come out?
That's correct.
It's not my role as the arbitrator to elicit essential information. It's their roles as advocates to make sure I have that essential information.
Advocates in arbitration argue for their respective sides. Some advocates are lawyers, some are not. Many non-lawyers are excellent advocates, while some lawyers are not. So there is sometimes a disparity of skills in the hearing room. What happens then?
When I find an imbalance in the playing field at arbitration, I do feel it's my role and my job to make sure that people are treated fairly and that each side has its full opportunity to present the case it wants to present. But beyond that, I'm not going to take a side to assist one party or the other if they're not good presenters on their own. I don't think that's our role, and I wouldn't want to be thought of as an arbitrator who picks the losing side and goes to bat for it. I think that's inappropriate.
Arbitrators sometimes make site visits to experience firsthand the issues involved so they can make an informed decision. Ms. Golick remembers the time that workers filed a grievance claiming they were entitled to $10 a day extra pay because they regularly had to climb tall towers. And they wanted Ms. Golick to experience how dangerous that was.
So this was early in my career where I was still trying to make as good an impression as I could make, and I am desperately afraid of heights. Climbing an outside tower into the air, 80 or 100 feet, was just about the last thing I wanted to do, but I didn't want to admit that I was fragile.
So did you do it?
I did it. When I finished the hearing, I was as convinced as they were that climbing these towers day in and day out was indeed worth a $10 a day bump. So I sent my decision sustaining the grievance and added $10 to my bill.
When Jim Harkless was told that a coal mine was unsafe, he donned a steel helmet and walked deep into the mine to see for himself.
It was very arduous getting down the slippery, although there were steps, they were not well kept. There was a railing you had to hold on to very carefully. There was mud, and we walked probably at least a mile down into the mine. And then we had to walk back up. But I did decide that it was unsafe. The point is that all of the arbitrators, including myself, this is a very responsible thing to do, to make these determinations as to whether something's safe or unsafe, because it can have serious consequences if the arbitrator is wrong.
So arbitrators weigh their decisions very carefully.
When the briefs come and the transcripts come and you reopen that book of evidence and begin to relive that case, to me it's like walking back into the hearing room, and you remember who the people are, you remember what they looked like, you remember, of course we take notes even when there is a transcript, so we have our own impressions of the hearing as it is unfolding. But for me, it's like walking back into the case, and that's when I do my serious studying of the parties' positions and the evidence and start my writing. The writing is a challenge, and it should be a challenge. It's the most important part of decision making, in my opinion. I know that the analysis of a case is incomplete until it's written, and it's written well.
But understanding what really happened in a dispute is often difficult.
Higher date was April 16th, 2009. Objection.
Actually, one of the reasons, in my view, is that parties don't resolve questions before arbitration is because they can't agree on what happened. So for me, the facts are the heart of any arbitration case.
Writing down the facts can be a visceral experience.
I picture it, the image in my mind is like consuming the facts and having them inside. There are arbitrators who will say that they use assistants to write the facts and that the only thing they write is the analysis. I would be at a complete loss, or at least I would feel very, very insecure if I had somebody else write the facts and I sat to write the analysis. I ingest the facts as I write them. It sets me up to be able to really analyze where the decision is going.
Distinguished arbitrator Arnold Zack has his own style of decision writing.
So my pretty well adhered to rule is to write up the facts of the case within 24 hours of hearing it. And that creates some problems when you get multiple day hearings, but on a single day hearing, write up the facts, that because I don't have to look at my notes. I'm not led astray by one-sided recitations of the facts that come in post-hearing briefs. And when you start doing the writing and you're doing it from without the briefs, even without the transcript, I mean, I keep notes on everything, and handwritten, and you really get the nub of the case, and you do it very quickly, and I think you do it much more efficiently.
And his opinions are famously short, agreeing with his mentor, legendary arbitrator Saul Waller.
Saul used to say, the less you say, the less you have to defend.
But there are deeper goals in decision writing.
You're writing for the parties in many senses. You're trying to preserve the relationship, that don't make it worse than it was. So if there's an individual grievant there, you want to make sure that what you've written is understandable to not only him but everybody else.
And when drafting a decision, what if it just doesn't feel right?
You write that opinion after listening to everything, and it doesn't hang together. It doesn't really do it. There's something wrong here. And you go back and rethink, and eventually you come out with the right decision and the right way to express it. You agree?
I do agree, and that, I must say, is one of the more troubling times, is when you can't make that decision hang together and you don't know why, and then all of a sudden you realize it's because the answer is not the answer.
Yeah, that's right. It was wrong. Something's wrong here.
In a National Academy fireside chat with arbitrator and University of Michigan law professor Theodore St. Antoine, arbitrator Rich Block remembers the philosophy of opinion writing endorsed by his professors when he was in law school at Michigan.
And they stressed writing and thinking carefully and turning the phrase and being careful because this had to be read on the plant floor and making sure that you were not screwing up the labor contract for these people who, after all, had to work together again tomorrow. And one night at a party with Russ Smith, I said to him, with some pride, I had just finished a really difficult opinion. I was expressing the pride that I had taken in crafting this. And I said to Russ, well, how do you feel about it? Do you still get the same thrill after all this? And he said, well, after 45 years in the business, I've come to the conclusion that they pretty much all just turn to the last page. What's your take on that, Ted?
I think they often just look at the last page. And about that ruling on the last page, Mr. St. Antoine points to a telling quote from Supreme Court Justice Louis Brandeis.
And the quotation is this: "It is more important that I decide this case than that I decide it correctly. Whenever I worry that I'm going to come up with a terrible decision, it consoles me that whether it's right or wrong, it lets the parties move on. It gets the business done. It puts the issue behind us. And I think that that's a very substantial part of the role that we play in this profession."
And some additional advice.
Decide every case as if it were your last case. And you know, even for us academics, who I don't think worry quite as much as the full-timers about the next case coming up, we still don't like rejection. And when I'm deciding a case in favor of the employer for the third or fourth time in a row, you really do wonder what the union reaction is going to be. And I keep thinking, Ted decided as if it were the last case you're ever going to decide.
We're going to get started now. Good morning. My name is Walter True. I'm the impartial arbitrator appointed to hear this case. I'd like to start out by marking some joint exhibits.
And joint two?
So what did the parties really want from an arbitration? Harry T. Edwards is a federal judge on the U.S. Court of Appeals for the D.C. Circuit. Before that, he was an arbitrator.
In court, you have control because you're the judge, but in arbitration, it's trickier than that. And I found that most of the people with whom I work on both sides of the table wanted it to be a no-nonsense experience. They wanted fast turnaround. They wanted good opinions, but they wanted them quickly. But they mostly wanted you to be in control so that their constituents would have confidence in the process. That was the way I was reading it. And they knew they would lose sometimes, but they wanted a process that would allow them to say to their constituents, even though they were on the losing end, you know, look, the arbitrator did this, he ran a good hearing, we had a chance to present our case, it was a fair resolution, move on.
What happens if one party wants to appeal a decision? Remember the Steelworkers Trilogy? The Supreme Court ruled that the grounds for vacating an arbitration decision were very narrow, so the rate of appeals is low. But George Nicolau has encountered judges on the lower federal courts who vacate decisions simply because they don't like them.
If there's some policy that they can use to vacate that award, they will do it. It comes up in alcohol cases, comes up in drug cases where the court just isn't satisfied that you shouldn't have done that, put that man back to work, you know. And so no matter how many times the Supreme Court tells them that the review process is narrower than that, some courts just, I'm sorry to say, aren't paying attention.
So among all the other qualities an arbitrator needs in deciding a case, courage is key. George Nicolau believes in the words of Burton Zorn of Proskauer Rose.
He said, you got to look at it closely, make sure you're right, but above all, you have to be fearless. And what he meant by that is that you don't think about tomorrow. You know, you don't pander. you decide the way it should be decided. And if there's anything that I try to teach younger arbitrators, it's that. If you're good, the cases will come. But if you try to lean one way or another on the theory that that might help, or it's something that you are afraid of, you're in the wrong place.
I have heard, and I'm sure you have heard, from people that you would anticipate would be smarter about these things, that, well, yeah, but you know, over time, you gotta balance it out. You have to make sure that labor wins enough to maintain respect for your decisions.
Nonsense.
That's a very polite way of saying it.
Do you agree that it's nonsense?
100%.
Yeah, right.
And incidentally,
You can't live that way.
of course you can't, and my experience has been the pros we deal with know very quickly if your decision is somehow unsupported by the facts or the rationale. And there's no surer way to finish your career.
Yeah, they feel it right away.
George Nicolau has always been fearless in his decisions. Take the infamous collusion cases in baseball when owners worked together to avoid competitive bidding for players. From 1985 through 1990, 3 cases shook baseball to its core. Mr. Nicolau arbitrated collusion 2 and 3 during 108 days of hearings. In 1988 and again in 1990, he found that owners willfully violated the players' contracts.
I knew this was going to cost the league and individual clubs millions of dollars. But that was the decision that the facts required. And I sat down in my living room and they read what I was going to sign. And the Player Relations Committee guy was kind of, you could see he was not particularly happy and all that stuff. But I knew that as soon as I put my signature on that paper, that I was going to be fired because it was going to cost millions of dollars.
In the end, the league was forced to pay more than $280 million to the players.
I didn't get fired. I stayed there 8 more years, handling whatever cases they brought. And, that's the reward, in effect, that you get.
In 1992, Mr. Nicolau had another baseball case, one that posed the power of Baseball Commissioner Fay Vincent against his power as arbitrator.
Steve Howe, he's been like Superman. He's going to have to be that right now in this situation.
And the 3-2 from Howe. Down to third. Out there. Out at first.
All-star New York Yankees pitcher Steve Howe had a drug problem. Commissioner Vincent suspended him multiple times, but agreed to let him play again if he underwent regular drug testing. A year later, Howe was caught in a cocaine sting operation. This time, Commissioner Vincent banned him from baseball for life.
And the question was whether that was, in essence, for just cause.
A psychiatrist found that Howe suffered from ADHD, attention deficit hyperactivity disorder.
Without that, he would not have been dependent on either drugs or alcohol. And the other element of the case was that he'd been back for at least a year and he had never been tested. The commissioner did not do what his own people said had to be done. And I thought those 2 elements required that Steve have another chance. So I reinstated him. Fay was not happy with that decision. I think he's probably still unhappy with the decision because it was a question of the commissioner's power. I mean, it was kind of a tough case sitting there saying, well, the commissioner has the authority to do this kind of thing. Should I judge it? But I also thought about the fact that a ban for life is very, very harsh.
Mr. Nicolau's empathy highlights one way arbitrators and judges approach a case. Roberta Golick sees two different kinds of emotional approaches.
One is that a judge approaches a case with an empty mind as a machine, and the facts and the arguments are fed into this machinery, and it gets all processed, and at the end of that process, the judge has thought, click, 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 and here is the answer. And that's what you would call the deliberative process of decision making. The other school of thought recognizes that arbitrators are human beings and come to this process having lived lives, having lived in families, having feelings and emotions and responses on visceral levels beyond simply the processing of information.
Golick's distillation of that view?
Everything that has happened in our lives and everything we viewed has some influence.
Being a woman certainly influenced the lives of female arbitrators. For years after the National Academy of Arbitrators was formed in 1947, there were very few active women members. Even as late as the 1970s, there were only 5, all powerhouses. Jean McKelvey, Alice Grant, Eva Robbins, Marcia Greenbaum, and Frances Bairstow. As strong and bright and accomplished as they were, they all faced bias.
I go in and all the parties are there waiting for me to come. I sit at the head of the table. I take out my pad and pencil, get ready to go, and I said, well, we want to get the names of the people who are here and what they're doing. And the union president to my right said, just a minute, man, don't you think we should wait for the arbitrator?
One of Miss Bairstow's favorite cases was that of a sailor who jumped ship to look for girls. When the ship's officer warned him he'd be fired the next time, he cursed the officer and told him what he could do. He was summarily discharged. During the arbitration, the sailor felt a pang of discretion in Miss Bairstow's presence.
He finally asked the attorney in French, is it all right? Can I tell her? And the attorney Jonas said, sure, it's all right. She's not a woman, she's an arbitrator. So he turns around and goes like this, he says, fuck you and your whole goddamn ship.
Wow. Roberta Golick first joined the Massachusetts Board of Conciliation and Arbitration in 1974 as general counsel. She soon became the first female mediator in the board's 100-year history.
The men, not all of them, but the majority of the men in that agency really wanted nothing to do with me. They had come out of the War Labor Board, were secure in their positions, and I think felt insecure by my coming on board, and particularly insecure when I expressed an interest in learning what it means to be a mediator.
She pressed on, became a full-time mediator, and later an arbitrator. Some male colleagues were willing mentors. Others harassed her, but that didn't faze her. And in 2011, as one measure of her success, she became president of the National Academy. For African American lawyers and arbitrators, the biases were deeper and the challenges worse. Jean McKelvey became a mentor to one of her favorite students, Harry T. Edwards.
Jean McKelvey was the first important one for me at Cornell. She not only led me into collective bargaining and arbitration and caused me to be interested in it, she gave me confidence. She believed in me in a way that was just inspiring.
But in 1964, he still had a tough time getting hired by the major firms.
I had a record that should have easily gotten me a job with major law firms if that's where I had chosen to go. And it wasn't going to happen because of race. And I was frankly told by many law firms in most of the major cities, candidly, it doesn't matter that you have law review, we're not going to hire a Negro. That's what they said. And I remember some of the firms, and partners were totally open about it. They just said, we can't do it, we can't take the chance.
But another mentor, Michigan professor Russell Smith, pushed on his behalf, and Seyfarth, Shaw, Fairweather, and Geraldson hired him. In 1970, he joined the law faculty at the University of Michigan and began to arbitrate. As permanent arbitrator for Republic Steel and the Steelworkers, one case in Alabama was especially memorable.
Lots of people came to the arbitration, having heard that I was there, and this was fascinating. Many of them were like my grandparents, and a number of them pulled me aside afterward to talk to me and tell me how proud they were and kind of pat me on the back and urge me on. But what was funny during that occasion was the company attorney who I had, we all had gone through this, those of us who arbitrated. He was a wise guy and a smart aleck, and he pushed the envelope all the time. He objected more than, and finally at a certain point, as we've all done, I said, stop it. One more time, the case is over, and you'll lose. That's it. And he backed down, he stopped. Well, the audience was stunned. And it was an amazing, they could not comprehend this black guy up there telling the white attorney, sit down, keep your mouth shut, otherwise you lose. And it was an amazing experience for me, and it told me how far we were beginning to, we hopefully would come in the days ahead, because these were things that they had never seen before.
Jim Harkless arbitrated many United Mine Worker disputes in West Virginia in the 1970s. The miners and company reps were all white.
And I could tell that this was a complete new experience for them to see someone like me walk in. An arbitrator has to show a confidence, a self-confidence. I think I'm able to give the impression when I meet people for the first time that I'm a no-nonsense kind of a person.
All arbitrators feel deeply about their impact on both parties.
It's a lonely profession, often, because you're there struggling with the case. But when you think about the fact that they are putting it in your hands and trust you to decide, and will more often than not come back to you, even though one party is lost and the other is won. I mean, that's some feeling, you know, that you've really played a part in their relationship. You've helped smooth over that particular problem. Maybe they can get along better now and resolve the next one without you. Or if they can't, maybe they'll come back to you because they trust your fairness and your ability to understand what they're talking about. And what could be better?
Of course, sometimes arbitrators are not chosen again. In essence, they're fired. Ralph Seward, a National Academy president from 1947 to 1949, famously said, "You're not a professional arbitrator until you've been fired by somebody."
You know that whichever side doesn't prevail is going to be unhappy with you and not use your services again. It's part of the business, and we have to acknowledge it and just go on. You do what's right.
But even if they're fired, arbitrators are highly respected by the parties they serve, including the witnesses.
Witnesses tend to treat the arbitrator like the arbitrator is God. And in fact, most arbitrators think they are God, so they enjoy that kind of treatment.
But admiration for arbitrators runs deep. In the 1950s, Ted St. Antoine was on the staff of the Board of Monitors in Washington, writing herd on Jimmy Hoffa. Ted and his wife Lloyd had a poignant experience with the labor leader.
We went to the theater one night, and we were very early, and Jimmy Hoffa and his daughter were there. He brought the daughter over to introduce to us, and he said to her, "You know, Mr. St. Antoine probably doesn't think very highly of you." when you grow up, I want you to be the kind of person he is. And I must say, I did feel touched by that. She did go on to law school. She became a judge, as a matter of fact. And Jimmy, as you know, had a different fate.
Some arbitrators are known for their innovative spirit. For instance, Arnold Zack. In 1993, he helped devise a way to extend the protections of union management arbitration to employer-imposed non-union mandatory arbitration. More recently, he took his expertise to the international stage, working on behalf of the UN's International Labor Organization, the ILO. He has trained arbitrators and mediators around the world, but especially in South Africa, India, China, and Cambodia. His mission: to extend the message of collective bargaining in resolving workplace disputes and to replicate standards of fairness in all workplaces.
The ILO has 8 core conventions. In summary, no child labor, no forced labor, freedom of association, right of collective bargaining, and gender equity, no discrimination in the workplace. Those are the core values that I think provide at least a floor for a level playing field around the world. And that's what I've been trying to achieve. In labor management arbitration negotiations, I think is the best way of doing it. But the United States and Canada are the only countries that have collective bargaining, binding arbitration, private arbitration. Only 2 countries in the world. And yet it's a good model.
There are some interesting variations on the arbitration theme. Sometimes during a hearing, arbitrators see a chance to help parties resolve cases without having to go through the whole trial-like process.
I mean, yesterday, I had a case in which I'd made up my mind of the opening statements. And I told the parties to go back and talk for a while, and then come back if they want.
Sometimes what happens in the middle of a case is the other side has heard the evidence and knows that this would be a good time for us to see what is the best we can do to resolve this matter before the arbitrator hears any more.
Another variation is a mix of mediation and arbitration called Med-Arb.
I'm selected as an arbitrator. The parties know that I have a bent towards resolving matters, and they asked me at the beginning of the case if I would assist in trying to resolve the case informally through mediation. And they agree ahead of time that if it doesn't work, that I then put back my arbitrator's hat and serve out my role as arbitrator. I remember one of my arbitrator pals from many years ago was a true gentleman named Jack Higgins. Everyone still talks about Jack Higgins as the man who came into any arbitration case and left with a settlement, a mediated settlement, because he told stories and he was entertaining and everyone loved him. And it was a kind of dispute resolution that doesn't really exist that much, I think, anymore. He was really what you would call old school, and everyone loved him, and he could settle absolutely anything. He probably never had to write an arbitration decision.
Experience in arbitration has been formative for American leaders. George Shultz is former U.S. Secretary of Labor, Treasury, and State.
One of the things as I reflect on my career that strikes me strongly is that the training that I had in economics and in the labor relations and personnel area, in mediation and arbitration, has been extremely important to me as I tried to manage large organizations, as I was involved in all sorts of negotiations, sometimes of very big deals with the Soviet Union and arms control and things like that. And it's all very relevant. I learned a lot about managing people
I learned to listen. I learned that people love to learn. That if you can create a situation around you where everybody's learning, you're going to have a hot group. You're going to have to send them home at night.
So how do aspiring arbitrators begin?
If they have the opportunity to work as neutrals, that's great. To be apprenticed to somebody, that's great. But also, if they learn something about collective bargaining, either as an advocate for labor or management, or as a mediator, that's a valuable service because you understand what the collective bargaining process is all about.
We need to be picked, and that is the hardest thing for somebody who wants to break into the field. How do you get picked when people don't know you? And how will they know you if you're not exposed to them?
Like all arbitrators, it starts slowly.
Very slow.
And my advice to young folks who come up and say, how do you become an arbitrator? I said, well, you get a day job.
Very well, my own true love. This could have been Jim Harkless's day job.
My dear, for the ship lies awaiting and the wind blows free.
But arbitration is his real calling.
Away to the sea, Marianne. Over the course of 40 years, I have issued thousands of decisions, several thousands of decisions. I've seen all kinds of people all over the country. I've been exposed to every kind of industry, newspaper industry, airline industry, railroads. I feel that I know an awful lot about America, about American people. So it's been a great education for me, and I do know that I've made a difference in many, many lives.
I always kid about the fact that we're the least expensive person in the room in an arbitration, but I wouldn't change it for anything.
Nor would I, Mr. Miklau. Nor would I.
Well, there it is. Give you a sense of these. I'll quickly tell you just a little bit about the film. Then I want to talk a little bit about PERB, and we'll be through at the time we promised we get through. These are the excerpts that you saw are very often they're excerpts of 5, 6, 7, 10-hour interviews, part of a thing that the College of Labor and Employment Lawyers a project they have called the Video History Project. And it's an attempt to record the founding mothers and fathers of labor and employment law, get something down for researchers to be able to use in the future with respect to the history of labor and employment law. If you're interested in seeing a little bit more about this, you can go to the College of Labor and Employment Lawyers website, click on Video History Project, and you'll see excerpts from, probably 25 or 30 of these interviews. They're only 3 or 4 minutes long, okay? The entire interview of those particular people are housed at Cornell University. They're in the films they're available for researchers who are studying labor and employment law history. Ma'am? College of Labor and Employment Lawyers is the name of the organization. Just Google them and you'll find it very quickly. Then you go to Video History Project, and they'll show you all of the various interviews that we've had. Some very interesting ones. One is of Marvin Miller, the founder of the Major League Baseball Players Union. And it's a wonderful interview about how that union got started and what is involved in it. Okay, just a couple of points I do want to make. If you look at the notes that we gave you in advance, you notice that, and something I said earlier, the three areas that PERB will review an arbitrator's decision are exceeds authority, what was it I said? Contrary to law or procured by fraud. Now, how it gets to PERB? It gets to PERB because there's been a grievance filed. It moved through the grievance arbitration procedures of the collective bargaining agreement. The parties were unable to resolve it, and so they got an arbitrator. And how did they get that arbitrator? Well, usually they go to the Federal Mediation and Conciliation Service, or they go to the American Arbitration Association, and they say, give us a panel of it's always an uneven number, okay? Give us a panel of 3, a panel of 5, or a panel of 7 arbitrators. You can say who have some experience in our industry, some experience in DC government, some experience in sports, whatever it happens to be. And FMCS will send you a panel of 5. And usually there's some procedure, or they maybe flip a coin as to who is going to strike first. And so whoever's, let's say it's management, and so management looks at the 5, strikes off somebody that they wouldn't have in a million years, okay? And then the union strikes off someone they wouldn't have in a million years. Then management strikes, then union strikes. There's somebody left, and that's how the arbitrator gets selected. Then there's a hearing, and then the arbitrator issues his or her decision. Under PERB law, CMPA, at that point, it is final and binding. So the parties are bound to comply with that award. If for one reason or another they think the arbitrator is wrong, and the arbitrator exceeded authority, or the arbitrator's decision is contrary to law or public policy, or this never happens, or they think it was collusion, that somehow the arbitrator and the management or arbitrator and the union were together on this. It has to be one of those 3 things. And if they do, then they can appeal that to PERB. And as I say, PERB is very narrow. PERB requires that you establish just feeling that the arbitrator was wrong. That is not exceeding his or her authority. Definitely is not exceeding his or her authority. And just a couple of examples I want to give you. They both happen to be MPD cases, as a matter, interestingly enough. But they kind of focus very quickly as to what I'm talking about. There was a 2005 MPD case that was appealed to PERB. It involved a selection of police officers for the K-9 unit. And there was somebody who was not selected, an officer. The Fraternal Order of Police was unhappy with it. They filed a grievance. They took the case to arbitration, and they won. Okay? And the arbitrator ordered MPD to put this person in the K-9 unit. MPD objected, saying the arbitrator exceeded his authority. What were they saying? Well, they said that he didn't have the authority because this was contrary to the selection procedures of the collective bargaining agreement. In other words, you select people for the K-9 union by following the collective bargaining agreement. The arbitrator didn't follow that, and therefore he exceeded his authority. PERB blew right by that. That's exactly the kind of thing PERB said that arbitrators decide, and making that decision was certainly well within his authority. So there's an example. A second example involved another selection. I can't remember offhand now. The arbitrator concluded that the selection of this individual was of one individual. The employee was discharged. I'm sorry, the police officer was discharged. And the arbitrator ordered, the union wanted him reinstated. The arbitrator said, well, management wasn't all wrong here.
this guy shouldn't be an officer, but he shouldn't have been fired either. We're going to order him reinstated by MPD to a civilian job, okay? A civilian job at the police department. MPD took that to PERB, and in one of the very few cases where PERB has reversed an arbitrator, PERB said, yeah, the arbitrator did exceed his authority. He did not have authority to be making decisions for people being put in positions outside the bargaining unit. That's not within his authority. The arbitrator could have ordered that person reinstated. He could have ordered that person reinstated with a suspension of 4 games, or whatever it happens to be, okay? But he can't take and move that person from a police job, an officer's job, to a civilian job. So it doesn't happen very often, but that's an example. The second point that PERB, you can appeal to PERB is the arbitrator's decision is contrary to law and public policy. PERB doesn't get that many cases, but one case that I think is very exemplary of how strongly courts support arbitrators' decision is a case called MISCO, M-I-S-C-O. Okay. This case went to the Supreme Court. It's not a PERB case, it's a private sector case. It involved an employee who was discharged for smoking marijuana. Okay. The arbitrator ordered his reinstatement with suspension. Okay. MISCO appealed that case to the courts on up through and finally got to the Supreme Court. And what MISCO argued was that ordering them to reinstate someone who was smoking dope is a violation of public policy. The Supreme Court says, no, that really isn't a violation of public policy. That is within the arbitrator's discretion. And there's a wonderful quote. This isn't from the MISCO case, but it's a case that very much give you a sense of what how courts do look at these public policy cases. And this was a DC Department of Corrections and Teamsters Local 246 case. Case got to the the Court of Appeals. And the Court of Appeals says, in discussing what is public policy and how the DC Court of Appeals is going to look at public policy cases, it said, we must not be led astray by our own or anyone else's concept of public policy, no matter how tempting such a course might be in any particular setting. So the suggestion is that the question of whether an arbitrator has exceeded public policy or decided public policy is going to be a very narrow construction. Just because a particular judge, thinks that isn't the way he or she would have decided it, is not enough to set that arbitrator's decision aside. The last basis for appeals to PERB is fraud and collusion. And try as I might, I could not find any examples in the PERB files of a fraud and collusion case. So we'll just have to, you'll have to guess as to what the PERB would do in that. But I don't think the reason there isn't any is obviously because arbitrators are pretty reputable people. And lastly, interest arbitration. I'd like to just spend a couple of minutes on that. If you look at page 2 of your notes, you'll see item number 6, interest arbitration, under item number 6, interest arbitration. Interest arbitration, again, is not the kind of arbitration we saw in the film. That's grievance arbitration. Interest arbitration is where your agency and your union is unable to agree as to what's going to go into the collective bargaining agreement. So they come to PERB and they say, we're at impasse. That is, we've tried our best, we just can't agree. And so we'd like you, PERB, to resolve our dispute, and we'd like you to resolve it under procedures of the CMPA. So PERB at that point has to, if the executive director takes a look at it and is satisfied that there is an impasse, then PERB will select one of the half a dozen, if you look at the bottom of their page, methods of resolving impasses. And the very first one, by the way, they can pick any one of these, or they can pick 2 or 3 of them and try them in succession. This is something that, an authority that PERB has. For our purposes, well, mediation, of course, is where, as they said here, is when they sit down and try to get the parties to agree. Advisory arbitration is just that. It's not final and binding. Then there's binding arbitration. The one that's most interesting is final best offer arbitration. Okay. This is sometimes called baseball arbitration. Anybody know why they call it baseball arbitration? Why is it called baseball arbitration?
Because I think the name comes from what they've done in baseball, where the last best offer left on the table for the individual employee is what end up going to arbitration when they have.
That's right. That's right. The last best offer of the team and the last demand of the player is put before the arbitrator, and he or she has to decide which is the more reasonable. No splitting the difference. Regular arbitration, the arbitrator could split the difference if he or she wanted to. But in last best offer, the arbitrator has to just pick one, A or B, and that's it. Okay. And of course in sports, it's just usually just on salary. But in last best offer arbitration in industry or in an agency, it could be any number of things. It could be issues of funeral leave, vacation, office assignment, a whole bunch of different things. And the parties and the arbitrator, if last best offer arbitration is selected, if that's what's selected by PERB, then the parties sit down and they present their case to the arbitrator, trying to convince the arbitrator that their position is the more reasonable. And the arbitrator says, this one or this one. No splitting the difference. Okay? Splitting the difference could take place in item by item, which is another option PERB has. And if you can see that, that's item F. By the way, these are all set out in 617.02C of the in the blue book that you have in here. Okay, well that's our discussion of arbitration. I'm open for any questions. Yes, sir.
How often does it happen in last best offer arbitration? Like just before the arbitrator makes a decision, the parties decide, maybe we ought to settle.
Well, it's a good point. Thank you. One of the rationales behind last best offer, okay, is that if the parties realize that they're going to have to be stuck with their it's either or, okay, they are going to get more and more and more reasonable. No more pie in the sky demands. No more bought seller demands, hoping that the arbitrator will split the difference. Now they're going to be judged on which is the more reasonable. So that kind of brings them a lot closer together, and then very often they will say, oh, rather than pay an arbitrator, why don't we agree to split the difference? In other words, they get so close that they're no longer, it's no longer a big problem, and they can strike a deal. Now, how often that happens in DC government, I don't know.
You can reach consensus on non-comp issues. On comp issues, they are rigid.
Oh,
so,
I'm sorry. Of course, yeah. What we're talking about here, I think, are almost entirely PERB acting in 61702. I think it's talking about non-compensation bargaining. Am I right? Yeah, these are the non-compensation. I didn't even try to get into compensation bargaining. I don't.
What you described very well with the compensation
Okay.
resolution is an interest arbitration.
Okay, all right.
Last best offer from either side is what the arbitrator looks at and makes a decision on one or the other. And what in our case, what happened was at mediation, when the district had to look at some of its proposals on non-comp issues, we were able to reach consensus, and we have 44 articles in our contract on all but about 6, and the 6 were related to compensation, and that ended up in interest arbitration.
All right. Any other questions? Yes, ma'am.
Why is it that you have arbitrators that, for example, when you're on a panel that you're going in a training, that they have there's such polar opposites in their decisions for the same case?
You mean, are you talking about where you have a panel of 3 arbitrators hearing the same case? Well, usually, okay, those kind of situations, there's a union arbitrator, a person who's unabashedly with the union. Okay. And then there's a management person who's a management guy. I mean, in fact, they're very often coming from the ranks, union leadership and management leadership, and then there's a neutral arbitrator. The main reason for that is that the parties want to be sure, they know that the neutral arbitrator is going to decide the case, but they want to make sure that when the ad arbitrator sits down to make his decision, he's going to have before him, in fact, in the very room with him, a union person and a management person who can make sure he understands what the union's position is, make sure he understands what management's position is. They know that the decision is going to be a neutral decision. Those arbitrators, by the way, the neutral arbitrator is very, very pleased when he actually can get both sides to agree with him. That's when an arbitrator is really proud of his accomplishments. It doesn't happen very often. You know. They have to go back. They have to go back to the union hall, or they have to go back to management. You know, they don't want to be viewed as having sold out. So, any questions, sir?
Once PERB renders a decision, is it subject to the process of
Enforcement.
Yeah.
Is that what you're talking about?
Right. Well, I know with the National Labor Relations Board, someone can file an exception to what was rendered. Is that the same process with PERB?
Well, no. The fact that they've come to PERB would be sort of like filing of exceptions. In other words, they've got an arbitrator's decision. They're unhappy with it. They think it violates one of those 3 principles. So they say, we're not going to comply. We're not going to put this guy back to work. Never. Okay. So then the union would come to PERB and say, we've got an arbitrator's decision. They're not honoring it. We'd like you to tell them to do it. And PERB then will have a proceeding and take a look at the arguments, pro and con. There might be a hearing. Is there always a hearing? No, there's not always a hearing. But they'll make the decision pro and con, and then the PERB will decide. If at that point, then, okay, let's assume management says, I don't care what PERB says. I'm not putting that bum back to work. Okay. At that point, then, they have to go to Superior Court and to get an order from the Superior Court telling them do it. And then if they don't do it, it's contempt of court. That ain't nice. That ain't nice.
Would that be a 10-J injunction?
Well, it would be, it's not a 10-J injunction, but it would be comparable to it, except that a 10-J injunction is a temporary injunction. This would be more or less a final order. You know, you could go further up the ladder in the courts, but the chances of you getting anywhere is slim. Anything else? Oh, I'm over time. Thank you all. I enjoyed talking to you.
Okay. Thank you, Mr. Wanted to remind you just to slide your comments down to the end of the table and we'll collect them. My staff has informed me they won't be
want you to know that all of our cases can be researched on Westlaw. And then I wanted to let you know that we're revising our rules. Hopefully they will be published next week, if not the week after next, in the DC Register. Please, we'll probably send out a notice to all of you, letting you know, asking you to look at them and give your comments. We'll be looking for public comments and before they are finalized. And thank you again for coming.